Assalamualaikum warahmatullahi wabarakatuh. My name is Ahmad Haziq Al-Fayyid bin Muhammad Ahbali. Message number 1201635. I will present to you about Islamic law in civil court and jurisdiction conflict. Thus, Article 121, Clause 1A solve the conflict of civil and Sharia court jurisdiction on interfaith child custody dispute. If yes or no, how? The answer is no, because it is clear that to speak of Article 121, Clause 1A having taken away the jurisdiction of the civil court in all matters pertaining to Islamic law is a fallacy. Article 121, Clause 1A was not introduced for the purpose of ousting the jurisdiction of the civil court. The Federal Constitution. In Article 121, Clause 1A, the court referred to in a Clause 1 shall have no jurisdiction in respect of any matter within the jurisdiction of the Sharia court. The meaning is which provide that the two civil high courts shall have no jurisdiction in respect of any matter within the jurisdiction of the Sharia courts, was in many ways to avoid for the future any conflict between the decision of the Sharia courts and the civil courts. The fact it is submitted, therefore, that even if the basis of challenge of the jurisdiction of a court is not constitutional, when the question is whether a party or subject matter or otherwise to an action is a Muslim or not, it should logically follow, given that there is a 50-50 or whatever chance that the relevant party may not be a Muslim, and so the Sharia court would never have had jurisdiction over him. The question of fact to determine whether he is a Muslim or not must always be determined by the civil court, because at least the civil court has jurisdiction over Muslim and non-Muslim, save that in certain matters of substantially personal law they are deprived of jurisdiction over Muslim, whereas Sharia court ipso facto never have jurisdiction over non-Muslim a priori if it is determined that he is a Muslim and the matter is clearly within the jurisdiction of the Sharia courts. It shall be dealt with thereafter by the latter court. High court judges should never abdicate their duty to deal with such case properly and obviously and not pass the buck. And indeed, jurisdiction willy-nilly by merely referring to Article 121 Clause 1A and declaring supinely that it has taken away jurisdiction from the civil court. For the case law, Viren anak lelaki Nagapan versus Deepa anak perempuan Subramaniam and other appeals 2016 MLJU 05. The issue of conflict of jurisdiction between the civil court and the Sharia court, learned counsel for the ex-husband submitted that the civil high court has no jurisdiction to grant the custody order of the children to the ex-wife. The reason being that the ex-husband and the children were already Muslim before the filing of the divorce petition, and custody order for the children by the ex-wife at the civil high court. It was argued that the Sharia high court had rightly exercised its jurisdiction in dissolving the ex-husband marriage with the ex-wife and thereafter granting the custody of the children to the ex-husband, since the matter is within the jurisdiction of the Sharia court. The civil court has no jurisdiction in respect of the said matter. Next, on the other hand, learned counsel for the ex-wife contended that Article 121 Clause 1A will only apply when the Sharia court has acted within its jurisdiction. It was submitted that in the instant case, the Sharia High Court has no jurisdiction to make the custody order, as the civil court still retains the jurisdiction on the custody. of the children of the civil marriage between the ex-husband and the ex-wife, despite the ex-husband's conversion to Islam. In support, Learned Cousin referred to as Section 3, Clause 3 and Section 51 of the LRA, which reads 3. This act shall not apply to a Muslim or to any person who is married under Islamic law, and no marriage of one of the parties which professes the religion of Islam shall be solemnized and registered under this act. But nothing herein shall be construed to prevent a court before which a petition for divorce has been made under Section 51 for granting a decree of divorce on the petition of one party to marriage where the other party has converted to Islam, and such decree shall, notwithstanding any other written law to the contrary, be valid against the party to the marriage who has so converted to Islam. Section 51, Clause 1. Where one party to marriage has converted to Islam, the other party who has not so converted may petition for divorce, provided no petition under this section shall be presented before the expiration of the period of 3 months from the date of the conversion. The courts, upon dissolving the marriage, may make provision of the wife and or husband, and for the support, care, and custody of the children of the marriage, if any, and may attach any condition to the decree of the solution of as it think fit. The conclusion: the intent aimed to avoid for the future any conflict between the decision of the Sharia court and the civil court of the amendment which created Article 121 Clause 1A has not only not materialized, it has, in the event nearly 20 years later, had the very opposite effect. Unfortunately, it appears to have caused even more confusion, uncertainty, and conflict than ever was the case. It is clear that to speak of Article 121 Clause 1A having taken away the jurisdiction of the civil court in all matters pertaining to Islamic law is a fallacy. Article 121 Clause 1A was not introduced for the purpose of ousting the jurisdiction of the civil court. The Sharia court are inferior court that inhabit a sphere within the judicial space which is inferior to the superior civil court, that is to say, the High Court, Court of Appeal, and the Federal Court. That's all from me. Thank you.